Ladies and gentlemen, welcome to the House of Kayfabe. My name is Brian Resner, and I am sitting here with the trial chief, Stephen P. New. How are you, Mr. New?
Acknowledge me.
I always do. Always
Yeah.
acknowledge the trial chief. So we've got some new developments in the Vince McMahon case, and Vince McMahon has now legally responded. Tell me what we're looking at with this response from Vince McMahon.
All right. So the lawsuit, the complaint was filed January 25th. And what that means is under the rules of civil procedure, a plaintiff has 90 days to serve that lawsuit on the person or persons they've sued. And so Janel Grant had until roughly April 25th to actually say, Mr. McMahon, you've been served. And what this filing tells me, being on April the 23rd, was that somewhere around April 3rd, Vince McMahon was served with the lawsuit because his response, whatever it was going to be, whether it was an answer where he goes paragraph by paragraph and admits or denies, or a motion to dismiss, or in this case, a motion to compel arbitration. So sometime in the last 20 days, Vince McMahon's been served, or they've agreed that some responsive pleading was due by a certain deadline, and they have filed that responsive pleading, that being a motion to compel arbitration.
So now, let me get this straight. This is basically a plea of innocence on top of a change of venue or change of...
It's not a change of venue per se. Let me explain first what arbitration is, okay? And I'm going to be completely honest with our viewers tonight. I despise arbitration. I despise arbitration, okay? And so I am not objective about arbitration. Our founding fathers in 1789, when the Bill of Rights came to us as a country, your Seventh Amendment God-given right is the right to trial by jury of your peers. Okay? It's in the Bill of Rights, one of the first 10 amendments to the United States Constitution. In the 20th century, arbitration started to get popular. And that was where people would give up their right to sue in order for what was supposed to have been a quick, inexpensive method of resolving a dispute. In a lot of your consumer contracts, it says that if there is a dispute, that the parties agree to arbitrate. The fine print in your cell phone contract, no matter what it is, more likely than not, there's an agreement in there that you agree to arbitrate and that you agree probably not to join any type of a class action. The reason why I hate that is because I'm a trial lawyer. I believe that the right to jury trial is sacred, and also because it doesn't cost you any money to file a lawsuit. It costs you a filing fee, but if you have a lawyer on a contingency, it may cost that lawyer some money to advance the case, but it doesn't cost you to have to arbitrate. If you are arbitrating, then you have to go through either AAA, the American Arbitration Association, or JAMS, and I forget what JAMS stands for at the moment, but those are the two big organizations, and there are people who are approved arbitrators on a panel. And the parties can either agree to who their arbitrator or their arbitrators are, or if they can't agree upon one or three arbitrators, the organization will select one that they think is best fit for the case. So that is the difference between litigation in a courtroom in state or federal court and arbitration, which parties can agree to do privately, and then it has to be paid for. Had a case recently where the people had agreed to arbitrate something, and these arbitrations are done by either retired judges or professional arbitrators, and they say, okay, we'll arbitrate this matter for you all, but we need $20,000 from each side as an initial retainer. That's the kind of a barrier that normally doesn't exist in litigation.
Right. Okay.
So that's the difference between arbitration and litigation. Now, if someone believes, as Mr. McMahon here does, that their matter should be heard in arbitration, then that's why they filed this type of a motion. Your Honor, this case should have never have come to you. If Ms. Grant had a dispute, we should have gone to arbitration first. So that's what we need to break down this evening, Brian.
Real quick before we get into that breakdown, let our viewers know what benefit does Vince McMahon have in arbitration that he doesn't have in a courtroom?
The benefit that he has is that just exactly what I just said. The matter will be resolved, if at arbitration, by either one arbitrator or a panel of three. It will not take place in front of a judge or a jury.
Right.
And so all of the things that you think about typically with admissibility of evidence and that type thing that a judge does, and then jurors are often called the judges of the facts. They weigh credibility of witnesses. They weigh the evidence to figure out whether the plaintiff, the person who's brought the lawsuit, has carried her burden of proof. But here, there is no jury. There is either one or three arbitrators who will make a decision as to whether or not Ms. Grant has prevailed.
Now, do you still go through the process of discovery with arbitration?
You do still go through the same process of discovery. There are different rules that apply, so you may not get as many written questions. You may not get as many document requests. You may not get as many depositions as you would under the federal or state rules of civil procedure. So, it's similar but not the same.
So it's like court light.
Kind of like court light. The rules of evidence, the rules of procedure are a little bit relaxed. The first arbitration I did was in 2001. It concerned a hospital construction in Ashland, Kentucky, and we represented the builder. It was against the hospital who kept making all of these changes to the hospital construction in the parking garage, and we prevailed. Just not as much as our client wanted, but it was still overall, it was, we prevailed.
Okay.
Yeah, and it took place in a hospital conference room. I mean, it was somewhat informal, and so it's kind of like court light, but there were a panel of three arbitrators who, and because they are either retired judges or experienced attorneys, a lot of the stuff that you have to do in terms of laying foundations for evidence that you would have to do in a courtroom before a judge and before a jury, they just hand us the documents. If this is going to be your next exhibit, let's see it. So in some ways, it is a streamlined court process.
So as far as the response goes to these accusations, what stands out to you?
Well, the first thing that stands out, all of this is excellent lawyering. All right. I just want to say, and I complimented the plaintiff's attorney on the very detailed complaint that started all of this, that was filed on January the 25th. I want to compliment these defense lawyers because they came out guns a-blazing. Motions to compel arbitration don't normally read this way. So I think these defense lawyers thought, we've got to match energy with energy here. You know, if they're going to come out and they're going to talk about Vince McMahon engaged in sex trafficking and defecating on this lady's head, and she essentially was, his sex slave for a number of years, they've matched energy with energy here. So the preliminary statement portion, contrary to plaintiff's false allegations, plaintiff and defendant engaged in a consensual relationship during which defendant never coerced plaintiff into doing anything and never mistreated her. In fact, in a love letter wrote to defendant shortly before the parties ended their relationship, she described Vince McMahon as my best friend, my love, and my everything, praising him for the wonderful, tender, vulnerable, hard on your sleeve soul you really are. So that's interesting.
It is, to say
She
the
could have
least.
written that of her own accord, or Vince could have paid her to write it, or forced her to write it,
Or maybe completely fabricated. Maybe someone completely different wrote it.
Now, what I think is interesting, it says it is incredulous that plaintiff, a then 42-year-old woman who claims on her resume to have a law degree from Pace University, would have written these words to defendant months after all the events in the complaint of alleged abuse, coercion, and sex trafficking. And then they start hammering her right here. 42 years old, not some young girl. An aspiring actress. You know, she was on a reality show. I want to be the next whatever. They talk about her around-the-clock caregiving, from the affidavit of due diligence, and it said plaintiff was so absent in her parents' lives that it took substantial time and significant effort for the creditor in the action to locate her and identify her as her parents' next of kin.
That's not the picture that was painted in the original complaint.
No, it is not. And then it goes on to say, and if you recall, a lot of people were asking, and on our group chat and things, how was this girl, if she's taking care of her parents and they're about to lose their home and all of that, how's she living in a luxury multi-million-dollar building in one of the most expensive zip codes in America? She was living at Park Tower with her longtime fiance, Brian Goncalves. Since August 2002, he was on Televisa Univision and previously held positions with MasterCard and Hewlett-Packard. And just 4 floors below McMahon, when the parties began their affair in 2019, she would visit him in the middle of the night and then return to Goncalves. And they say, look, it doesn't make any sense that she would have gone up to Vince's place 4 floors above, been the victim of coerced sex and forcing plaintiff to be defecated on before returning to her lawyer fiance 4 floors below without incident.
Yeah, well, now here's a question I have for you.
Okay.
Is, if she was living with her boyfriend 4 floors down, why wasn't that in her complaint? Because the way the complaint read, it sounded like she lived with her parents. And this, it seems like, the reason why she was in this building was because she was dating this lawyer, and the lawyer never came up in the original complaint. Nothing was said about that. Why do you think that wasn't in her original document? And does that change your mind at all about this case?
No, it doesn't really change my mind at this point. My mind changes with discovery. My mind changes when people are under oath testifying about things. I mean, there could have been any number of reasons why she and Goncalves had whatever relationship they had, and she was able to carry on the relationship, the affair, whatever you want to call it, with Vince McMahon. And so I don't know what those circumstances are, and you can't really tell until discovery goes. You get somebody in a 7.5 hour long deposition under oath where you get to ask them those questions after having already asked them a lot of those questions in writing and done document requests. But what they're doing here, what the defense lawyers are doing, is they're painting a picture. The plaintiff is a master of her complaint. So she can put in the complaint everything or leave out or skirt around certain issues. She just has to have a minimal amount of pleading to put the other parties on notice of what it is that she's suing them over. So as far as that goes, she's not compelled to explain all of these things. But this defendant, with these lawyers in this document, they're filling in some of the gaps, Brian. And that's why I said this is very high level lawyering here. Now, there's a lot about a lot of this that McMahon's lawyers don't address. They don't really deny the text messages, whether they were authentic, not authentic, that McMahon sent them or didn't send them.
Now, does that mean basically that those text messages were Vince, or else they would have said it wasn't?
Well, I think so. And I think what his lawyers are trying to say here is that, hey, that was just consensual. That was between two adults. That was between a 42-year-old woman and a 70-year-old man. And hey, but all of it was consensual.
So we've pretty much proven that Vince McMahon does text like a middle school boy.
Yes.
Okay. Just making sure.
So it says, after 3 years and having decided to return to their partners. So Janel Grant's going to go back to Goncalves. Vince is going to go to Linda.
Was she with Goncalves the entire time during this process? Like they never broke up?
That's what, that's the way this reads to me.
Okay.
They decided to return to their partners. I assume that's Goncalves and Linda. In January 2022, plaintiff and defendant agreed to end their consensual affair and separate from each other, with plaintiff leaving the company where they worked, World Wrestling Entertainment. They entered into a binding contract to memorialize that agreement entitled Confidential Settlement Agreement, General Release, and Covenant Not to Sue, which was Exhibit 1. You can't obtain that. So that's either been filed under seal with this document, or the court has placed it under seal, or something. Recall in our previous episodes that the only thing that the Janel Grant lawsuit makes reference to is an NDA. They don't make reference to a confidential settlement agreement, general release, and covenant not to sue. And I had even said the night of, when we had just had very little time to analyze that complaint, why are his lawyers not having her sign an actual release and not just some type of a non-disclosure agreement? Well, according to this document, they did have Janel Grant sign a confidential settlement agreement and release and covenant not to sue, which is much broader than simply an NDA. And so let's keep going. Parties,
real quick about the release.
Sure.
When you're doing a release like that, there's obviously money involved,
right,
in the agreement. And
right.
Then if the money was not paid, then does the agreement stand?
No, and we're not quite there yet.
Okay.
That's an excellent question, and we're not quite there. This is the funny part of this document. It's the weirdest, strangest part of this document, because for all of the other detail that McMahon's lawyers go into, this is very vague. Page 3. When defendant learned that plaintiff, despite her promises, had violated the agreement by wrongfully disclosing both the existence of the agreement and their relationship, he exercised his contractual right to withhold payment otherwise owed under the agreement. So McMahon is saying that after he made the $1 million, but before he made the next installment of what I believe is supposed to be $500,000, that Janel Grant wrongfully disclosed the settlement agreement and release and their relationship. Now, there's no detail about that. It could not have been the lawsuit that she filed in January of 24. So they're very vague about the manner in which Janel Grant allegedly breached the confidential settlement agreement and release. Keep that in mind, because I think that's the most important part of all of this.
So his lawyers were lawyering really well at that point too, to write him in an out of this agreement.
Well, sure, but this response presupposes that Janel Grant did that.
Right.
You know, and if I'm a judge, I want to have an evidentiary hearing on that, because I want to find out, did Ms. Grant in fact breach the confidential settlement agreement and release? And she intentionally violated the enforceable contract with her salacious, false, and defamatory public filing. So now, if you go over to the monetary considerations chart on page 5, McMahon will pay $1 million to Grant within 10 days, and apparently he did that, provided all confidentiality obligations of Grant under this agreement are complied with in ensuing years. McMahon will pay the following sums to Grant within 10 days of the dates listed. February 1, 2023, $500,000. My understanding is he didn't pay that.
Right.
So if McMahon didn't pay the $500,000 owed February 1st of 23, and she had not breached confidentiality,
then he breached it.
McMahon is in breach.
Right.
McMahon is the one in breach. As another example, plaintiff also demanded that the $3 million was to be paid as a lump sum. A compromise was ultimately reached that, as the agreement states, first $1 million to be paid upon the execution of the agreement. The rest was to be paid in 4 installments. She was supposed to get $500,000 February 1st of 23, 24, 25, and 26. In the event of any disclosure by Grant of the matters required to be kept confidential, McMahon shall have no obligation to make any payments set forth above. So if I were the judge, what I would be asking is, Mr. McMahon, tell me how, when, where, why Grant, prior to February 1st of 23, breached confidentiality such that you didn't have to pay that $500,000 on February 1st of 23. Because if he can't, then McMahon himself has breached the agreement, and I don't believe can use the agreement as both a sword and a shield. Okay? I think if he breached, then I don't think he gets to invoke the arbitration provisions. Says, and the rest of it's just that the language of the release, and she had counsel. I don't care how the release reads. I read releases probably every single day in my office. A lot of them are standard. A lot of them have standard language. By signing this agreement, Grant acknowledges that she will have waived any right she may have had to pursue or bring a lawsuit or make any legal claims against McMahon and or WWE and or any of its officers, directors, employees, agents, and representatives. So this release was so broad that if it were to be found to be legitimate, it would release McMahon, Laurinaitis, anybody associated with WWE. I mean, it's a really broad release document, and it contains an arbitration provision. We've already talked about what arbitration is. Let me see. This is AAA. In the event of any dispute arising out of this agreement, in its construction, interpretation, application, performance, or breach, the parties agree to first attempt to resolve such disputes informally and prior to taking any formal legal action to resolve any such disputes. In the event it can't be resolved informally, parties agree that the sole and exclusive method to resolve any and all disputes is to commence binding arbitration under the FAA pursuant to the procedures of the American Arbitration Association, and to do so by sealed proceedings, which preserve the confidential and private nature of this. So there was a provision in that. And what McMahon's lawyers are saying is, hey, look, even if he didn't make that payment February 1st of 23, and she says he owes me $500,000, that's supposed to go in sealed proceedings before AAA, and it's not supposed to be this salacious lawsuit filed just before the second $500,000 payment was due. So it's going to be real interesting to see how the judge rules on that. I could very easily see the judge saying, Ms. Grant, everything you say is all fine and good. And if you believe that McMahon owed you $500,000, if you believe that he engaged in sex trafficking or any of the other stuff that you've alleged in your complaint, you should have been in front of the AAA making those arguments. But the release language is very broad. Any legal claims, any against McMahon and or WWE, its directors, officers, employees, agents, and representatives. That is a really broad catch-all release. So this is the other thing. I love footnotes. I put the snarky things that I put in my briefs in footnotes frequently. If I want to jab the lawyer on the other side or whatever it is, I'll put that in a footnote many times. In this lawsuit, Grant is erroneously contending that the confidentiality provision is unenforceable. Defendant therefore reserves his right to, at the appropriate time and in the appropriate forum, demand, among other things, that plaintiff return the monetary compensation of $1 million, which defendant has already paid under the agreement. So that footnote is telling me is Vinnie Mac is going to probably countersue her in arbitration. If the judge compels arbitration, if Janel Grant doesn't go to arbitration, I think Vince McMahon is going to go to arbitration with probably a demand for the return of the $1 million and perhaps a defamation lawsuit, which we'll look at.
Well, that was going to be my question is if, big if Vince is exonerated and he comes out of this untouched, does he have a defamation suit? And does he have a suit against TKO for removing him before this all came to light?
I can't, on the second one, I can't answer because I don't know their agreement. I think so, and here is the reason why. There is probably in McMahon's agreement with TKO some type of a morality clause or an ethics clause or something, even if none of this came to light, and let's just say TKO learns of this privately, McMahon discloses there is a confidential private arbitration going on, TKO could probably say, we don't like what you did with an employee such that you had to enter into, because make no mistake about it, she was a WWE employee.
Mm-hmm.
Okay? We don't like the way you handled yourself with one of our employees. And so we're going to exercise that morality clause that we believe that you have violated and, demand your ouster from the board or that type thing. So hang on just a second. They go into their argument and they are on good footing. I will tell you that unfortunately, and this is part of the stuff that sticks a knife through my heart as a plaintiff's lawyer, is when you get geared up and you want to try to do something like, let's just say sue a wrestling company like WWE or AEW or MLW or
NWA, any of them.
NWA, Ring of Honor, Sinclair. You want to sue one of them, right? Because they've done something. Lo and behold, they have lawyers. The boys and the girls in the locker room don't. And there's this big arbitration clause right there in the middle of it. And they go through 9, 10, 11. They go through about 4 or 5 pages here, Brian, of nothing but case citation after case citation from the United States Supreme Court right on down about why arbitration is so frequently upheld by courts. And even on page 11, it says, the question of whether the dispute is to be arbitrated, the question of arbitrability is an issue for judicial determination unless the parties clearly and unmistakably provide otherwise. And here they're saying, whether this should be arbitrated or litigated, we want an arbitrator to decide that. So a good 4 or 5 pages of this agreement is spent fleshing out just all of that arbitration case law. Plaintiff's challenge to the enforceability of the agreement as a whole, rather than the arbitration provision, should be decided by an arbitrator and not this court. And they cite to a 2010 decision of the United States Supreme Court. So they go right on there. Hey, is the agreement as a whole, the settlement agreement and release, is it valid? Plaintiff's claims fall within the scope of the arbitration agreement. So they're saying that everything that she alleged, and this language is very important, the construction, interpretation, application, performance, or breach of the agreement renders the entire dispute a proper issue for arbitration. Now, they go on, because I think this is where Grant's lawyers are probably on their strongest footing. And Brian, because of the recency of this, there's not a lot of case law on it. But there was the Speak Out Act that was enacted, I think, either at the end of 21 or at the end of 22. That is a very new law. There is very little case law decided. What is that about? In count 1, plaintiff seeks to void the agreement based on the Speak Out Act, which renders pre-dispute non-disclosure clauses or non-disparagement clauses unenforceable in disputes involving sexual assault and sexual harassment claims. So an NDA that tries to silence a victim of sexual assault or sexual harassment is null and void on its face. So they go in here trying to say that Nothing in that law says you can't. Nothing in that law says you can't arbitrate that instead of litigate that in front of you, Your Honor. And they also mentioned the Trafficking Victims Protection Act. So this judge has got a lot heavy stuff that he's going to have to decide here, Brian. Does the Speak Out Act and the Trafficking Victims Protection Act trump all of this stuff about arbitration? And it is a person who alleges that they're a victim of sex trafficking and all of this other stuff. Do they get to stay in court instead of being directed to an arbitration? And then finally, they say the court should stay the action pending arbitration. What normally happens is very quickly, the court will give the parties some initial deadlines to meet, and disclosure witnesses to the other side. Put a scheduling order together and tell me when you guys want to go to trial and when your dispositive motions, your dismissal motions are going to be due, and things like that. And in addition to asking to compel arbitration, they're also asking, hey, judge, stay this case until you decide whether this case should be in arbitration or in litigation. And they cite some case law for doing that. So again, Brian, as I read this 22-page document, the exhibits, which was McMahon making an affidavit about certain things, that's not available. Their settlement agreement wasn't available. My staff got on Pacer and tried to pull that for me right before we recorded. It's not available. The filing itself, the motion, is available. So high-level lawyering on very technical legal issues here about arbitration and who decides whether it gets arbitrated, or are there things like the Speak Out Act that's really new that should take this outside of arbitration? But make no mistake about it, with these lawyers, some of which I understand represented MLW successfully against World Wrestling Entertainment recently for tortious interference with contract and antitrust, they've come out guns a-blazing here. They've called Janel Grant a liar. They've said that this whole way that she and her lawyer portrayed her in the lawsuit was a fiction. She's a 42-year-old failed actress who didn't care about her parents and who was into horses and was living with a fiance lawyer 4 floors below McMahon and had a consensual relationship with McMahon. So it could not be contrasted with the lawsuit, any more. And they didn't have to include a lot of that stuff in that preliminary statement. They have sort of gratuitously added a lot of that stuff. But does anybody expect anything less of Vince McMahon than when he's cornered to come out swinging?
I agree with you 100%. And honestly, before we wrap up here, I have to ask a couple of questions. So one question that I have is the claims about Janel's relationship with her family and the fact that she didn't care about her parents and that she wasn't actually taking care of her parents. Does that change the dynamic of this at all?
Well, I think as plaintiffs' lawyers, they got a 3-month head start on this. They got 3 months of free press about just what an SOB Vince McMahon was, even more so than the guy that killed the territories or, came up with the gobbledygooker or, whatever else, whatever other sin, that you can lay at Vince McMahon's feet. So they probably got what they wanted, the plaintiff's lawyers did, by portraying this girl, this woman, as an innocent girl. Not a 42-year-old living in a luxury apartment in a very expensive place to live with a fiance who's a lawyer.
Don't they also claim that the relationship with the lawyer was an open relationship, and he was completely okay with her relationship with Vince McMahon?
Right, right.
So
And which
where's this guy?
which begs a lot of questions. He could have been doing his own thing. You know, the definition of an open relationship is you can do whatever it is that you want to do. I'm going to do whatever it is that I want to do. You just have to be upfront and honest about it and disclose it.
Maybe he was dating Linda.
Maybe he was dating Linda. Maybe they swung. Maybe she's a beard.
Never know.
You never know. But I mean, that aspect of Goncalves' relationship with Grant, you won't really get into until you get into arbitration. So it's legally fascinating, Brian. It really, really is, because if McMahon breached, you've got this whole series of things of, did Grant breach by talking about this? If I'm a judge, I want to know the details. And if she didn't breach, McMahon, why didn't you make the $500,000 payment? But the agreement that she signed didn't say, if he breaches, we get to go to court and he gets a credit. If her lawyers had been smart negotiating the settlement agreement, that has said, all right, you miss a payment and you default, we're going to give you credit for everything that you've paid up to that point, but we still get to go to court and file suit against you, and you'll get a credit for the monies that you've paid at that point. But they didn't. That's not the way the settlement agreement was written up. The way the settlement agreement was written up was, hey, everything, including the breach of that agreement, has to go to arbitration.
So another question I have, and something that we didn't talk about in our other videos, was where John Laurinaitis and his response to Janel Grant's lawsuit comes into play. I mean, obviously, he believes that he was a victim too, and that that he was forced to be a part of this too, and he's being framed as the victim. Where does that come into play, and how does he even have the gall?
Hopefully, Johnny Ace has hired a better lawyer than the family lawyer who issued that statement very soon after the Janel Grant lawsuit was issued, because he needs to distance himself from that guy. Because if Johnny Ace and his hopefully new lawyer have read this motion by McMahon, then if I'm Johnny Ace and his lawyer, the only thing I file is a Me Too. I'm one of those officers, directors, employees of WWE that was a beneficiary of the confidential settlement agreement and release. I join with Mr. McMahon's motion, Your Honor. This needs to go to arbitration, and shame on Janel Grant and her lawyers for filing that salacious lawsuit. But I think that lawyer was ill-advised to say that Johnny Ace, like Janel Grant, too, was a victim of this, because those types of statements are going to support this whole idea that the Speaking Out Act should take this out of arbitration.
Okay, so we've done 3 of these. This will be number 3 of the videos that we've created about this Vince McMahon situation. And I'm sure that we have many more to make in the future as things start to develop, and especially after Discovery, which I know that we're both excited to see what's going to happen in Discovery. But I have one more question for you before we wrap up today. And that is, and I think I already know the answer to this question, but if you are looking at the Vince McMahon side and you are looking at the Janel Grant side, as a lawyer, which one do you think you could win?
I think with all of those pages of case law, and it depends on what a win is, right?
Sure.
A win for McMahon is to get this in arbitration and say, Your Honor, here's the $3 million, or Mr. Arbitrator, here's the $3 million. We've satisfied all of the terms of the agreement. The matter is closed.
Right.
The settlement agreement and release said she had to arbitrate. She didn't. Then that begs the question of, does McMahon want to try to sue her for defamation? Which of course, also begs the question of, does McMahon want to try to act like his bad reputation is all the fault of Janel Grant? And what a can of worms that's open. I mean, how much time you got, right? How far back do you want to go? Do you want to go back to Rita Chatterton in the 80s? Do you really want to countersue and open up that whole can of worms, 40 years worth of, rotten things that McMahon is alleged to have done? And is the Janel Grant lawsuit responsible for McMahon's bad reputation, or is it the 40 years worth of stuff that he had done prior to that?
But is that the question? Would the question?
It is the question.
Would the question? Would the question not be? The defamation is what Janel Grant brought cost him to lose his position with the company.
Maybe not. Now, only TKO could answer that. And TKO said, yes, we had no intention of getting rid of McMahon before this. We had no intention of forcing him to divest of X number of shares of stock or resigning his position as chairman. And, it's apparent from me, from the TKO acquisition, that they were going to leave McMahon in place.
Yeah.
He wormed his way back onto the board, and that they were going to leave McMahon in place. So his defamation case gets a whole lot stronger if TKO says that stuff. But in terms of damage to his reputation, then you get all of the other stuff that I'm talking about as well.
Absolutely. One thing that's kind of shocked me about this entire thing, and we touched on this in the first video, but we talked about the fact that this is not going to be the only one. You're going to see more of these come out. You're going to see more of this stuff. Now, my question, and I know I said I was already asked you the last question, but I'm going to ask you another one.
Sound like a lawyer. That's what I say in deposition. Two more questions. And then I ask a dozen.
So if, with that situation, you got Janel Grant, and you're expecting more. Do we not have more accusations from other people because they're waiting to see how this pans out? Or are there just not any more accusations from other people?
Well, it could depend on whether McMahon or whoever the lawyers were. Notice in this, they identified her lawyer that took part and negotiated Janel Grant's part of the agreement. They don't identify McMahon's. So I don't know who McMahon's lawyer was that negotiated that. The question is, would anybody else who may have been subjected to McMahon's conduct also signed a similar type of confidential release and settlement agreement?
And maybe they're not speaking because they got paid.
Right. Maybe they're not speaking because they got paid. If she was demanding the $3 million up front, it'd probably been smarter. I mean, if you're a billionaire, if you're worth $2.5 billion, give the girl the $3 million now. Don't try to stretch this out for $500,000 payments for 4 years to 2026, for Pete's sake. Just go ahead and give her the $3 million. Say you're paid. We better not hear a peep out of you. And that's the other thing. There are these clauses called liquidated damages clauses. And if they'd really been smart in drafting that agreement, they would have said, Ms. Grant, if you breach this, you owe McMahon 10.
Wow.
That would have kept her quiet. The liquidated damages for either party's breach of this agreement in terms of confidentiality is liquidated damages. You agree that liquidated damages of $10 million, which cannot be discharged in bankruptcy.
It's very hard to not perceive this as all about money. You know, we talk about abuse, we talk about sex trafficking, we talk about all these different things, but at the end of the day, this case is about money. If the money would have been paid, we would have never heard about this.
Right. Or I also don't know whether Janelle Grant's lawyers, what their demands were, or if they even made demands pre-suit.
Or tried to settle this outside.
Yeah, right. And say, hey, we believe that under the Speak Out Act and some other things, we have the right to file this in court and bring all of these allegations out and void the agreement that she signed. Give you a credit for $1 million, okay? And then make a demand, 25 million, 10 million, 15 million. Make a demand of whatever you want. We will never know that. Now, Brian, one thing that you said that I think was slightly an error there, if this goes to arbitration and an arbitrator finds, yes, it's supposed to be arbitrated, and we, AAA, are going to keep it and arbitrate it, then if it's upheld according to its terms, we'll never know anything about discovery or depositions because all of that is supposed to take place under seal.
Oh.
So if you want to know more, ladies and viewers at home, if you want to know more, you probably better root for Janelle Grant to win, not on the basis that you think she's right or that she should win or that McMahon should lose or anything else, but because you're nosy and you want to see the deposition transcripts.
So I guess basically one more question. Sorry, sir. That means that if that is upheld, this could be the last video because we may not know anything else.
Right.
It may just all go away.
Right.
Unless, of course, a defamation lawsuit.
Right, a defamation lawsuit. But, I mean, if you're Janelle Grant, Goose v. Gander, you say, well, if he's going to sue me for defamation, we've got to arbitrate it.
Oh, so that could be in secret, too. I can see why you hate arbitration. It is just not American.
It is not American, not in the least. I have always found in my legal practice the truth comes out with light, and having to be bound by arbitration, and those rules and no threat of a jury later on. The threat of a jury of 6 people, common everyday folks listening to this evidence, that motivates a lot of people to try to resolve their differences.
Absolutely. Well, thank you very much for your time today, sir. And thank you for letting our viewers know what your inside of your head talks about with Vince McMahon and his accusations. And
it really is high-level lawyering. Kudos, chef kiss, to both the plaintiff's lawyers that drafted that magnificent 87-page lawsuit, and kudos to these defense lawyers that came out swinging. I have been watching Vince McMahon as an announcer for his dad, 1982, 1983, whatever, and then he bought the company in 84. He fought the federal government in the steroid trial and won. And, he fought Ted Turner, who was a billionaire when McMahon was not one, and he won the Monday Night Wars. If anybody thought that he, at 70 or 72 years old, with $1 billion, $2.5 billion net worth or whatever, was going to take something like this lying down and not come back swinging, they don't know Vince McMahon very well.
That is true, and it's going to be interesting to see how this thing pans out in the future, or if we never hear about it again. But if we do hear about it again, we're going to talk about it again right here. So make sure that you click subscribe, make sure that you get all the alerts, and make sure that you share the video with as many people as possible so that we can get this message out. And we will see you back here when we talk about more hard things right here.
The GQ edition of the House of Kayfabe. Our co-host is going to have to step it up on the next episode.
Absolutely.
Myself included, because I'm usually on here in a hoodie and a ball cap because we're recording when it's dark outside, not when it's light outside. So
Right, but we just got off work and had to talk about this, so we went straight into the studio.
that's
And
exactly.
so keep listening, keep checking things out, make sure you're subscribed, and join us next time right here on the House of Kayfabe.